Hello, welcome to the Cello Law Weekly Wednesday webinar. Today is June 30th, June 30th, 2021. And we're so excited that you all are joining us today. Let's give folks a few minutes to get started. And today we're going to talk about all the buzz about the EB-5 that you've probably been hearing about past couple of days and how that can impact you. And so we'll give folks a few minutes to join. We'll talk about the EB-5 program, the latest changes, what can be expected, and how this can help you with your immigration strategies. I also want to remind people that we have been stating in almost every webinar, when people have been deciding whether they have a certified perm, whether they expect their perm to be certified, whether they've already filed an I-140 under EB-2 or EB-3, should they process another I-140 for another category? And the answer to that is if you are going to get your perm certified, or you already have a certified perm and you're trying to decide between EB-2 and EB-3, file both. There's no harm in that. And if you've already got an I-140, I-485 pending, during this interval, while you're waiting for your priority dates to be current, file in the other category. So you have both. And the tip is, all you have to do is, if you have an adjustment pending with one category or the other, you just have to simply interfile. And if you interfile, then you don't have to file a new I-485. So it's always good to have the EB-2 and EB-3 as we're trying to understand how these various categories are going to be advancing in the next year and a half, where we expect rapid advancement of both those categories. So don't miss out on this opportunity to make sure that you can leverage either process. And now, just a few administrative things. If you have a question, we'll do Q&A at the end. Please place your questions in the Q&A box and not in the chat box. So let's get started. EB-5, what is the EB-5 program? Well, the EB-5 program is a program where a person can invest. At one point, it was either $500,000 or $1 million, and then they increased the fees through a agency, notice and comment regulations to $900,000. I think it's 1.2 million. What's the difference between 500,000 and the higher range? Why are there two thresholds for investment? Well, it depends on whether the investment is going to be in a targeted employment area. A targeted employment area is either a rural area or an area where there's a high unemployment rate. So in order to boost investment in those areas, they put a lower threshold. And the other is the higher threshold is for localities where it's cities. And so really it's to incentivize people to invest in those targeted employment areas that really could use the economic boost. In addition, there's also things called EB-5 Regional Centers. And there's direct investments. What's the difference between the two? Well, the EB-5 Regional Center is a regional center that has already obtained certification from the Uscs that it is with a robust business plan. Most of the time, almost all the time, they have to submit information from, using an economic analysis to see what direct and indirect jobs can be obtained. And most of the time, they're in targeted employment areas. A direct investment is for an investment that has not been certified by the USCIS. So you have to submit a business plan. You can only use direct job creation because, remember, aside from the investment threshold, each investor has to create 10 jobs. And so in deciding whether to do a regional center investment or a direct investment, one of the benefits is the fact that the EB-5 Regional Center can leverage indirect jobs, construction jobs, and other jobs based on the economic analysis. Number two, there is some deferential treatment to EB-5 regional centers because they have already, the USCS has already reviewed their business plan, whether this is a bona fide entity that would be able to, create the jobs and so forth. Whereas with a direct investment, they're going to be looking at all of that de novo, anew. So they will review the business plan and they will review other things. And especially like last year, we saw in the pandemic where a lot of direct and EB-5s were impacted by COVID. But because the regional center can use indirect jobs, if you review the documents provided by a particular regional center correctly, you can assess how many of those indirect jobs are already calculated. So even if there's a problem with a short-term problem with the project due to COVID, usually they get corrected. Whereas with the direct investment, sometimes there could be a problem. So that's just the general background about EB-5. So what is all the buzz about? Well, the buzz is last year, the USCIS not only increased the threshold, especially from the lower threshold from 500,000 to 900,000, which is a tremendous increase versus the 1 million to 1.2 million, I think. But they also added all sorts of additional restrictions. Now, the problem was when President Trump took office, Nielsen was head of the Department of Homeland Security. And so when she was getting ready to resign, she adjusted who should be in succession. And when she adjusted who she should be in succession, then the acting secretary became Kevin McLellan. I'm trying to pronounce his name correctly. And recently, a federal district court in California said, hey, Kevin was not supposed to be the acting director of the USCIS. And that was based on the Federal Vacancy Reform Act, where it clearly stipulates how these succession rules should be placed. So what happened? They said they're going to discount the USCIS changes that were made last year. So the threshold came down to 500,000. One of the things that the USCIS argued was that, the DHS argued was that, well, the new acting DHS secretary certified it or ratified it in this year after he was cleared through Congress in the normal process. So doesn't that make it okay? And the judge was not. She said it's like the fruit from the poisonous tree. Even if you cleanse the fruit and it's from the poisonous tree, so it's still going to have poison in it. So no, it's nullified. And not only was it in this case, but there are a number of cases. And even the OMB said, the Office of Management and Budget, that Kevin McLellan did not have the authorization to act on behalf of DHS. So what happens when a federal district court makes a decision? How impactful is that? Well, the agency has two recourses. They can either appeal. If you remember, they did that with the public charge rule last year, or they can institute new, rule, and it has to go through the notice and comment of usually 60 days, and then they can stipulate new rules. It is most likely that they're going to choose the latter. I don't think this is going to be appealed because you cannot correct the issue that the acting director had the authorization by on appeal. And because so many courts have already ruled he didn't have authorization, I think it's going to be a tough fight for DHS to make. So most likely what they'll do is issue notice and comment if they want to proceed that way. There is another hiccup in this, which is the EB-5 reauthorization expires today, which is why we're talking about it. And historically, Congress has punted, continually extended it without really dealing with the long-term solution to this. They've done that, gosh, at least 20 times. And there have been periods where the USCIS has said, okay, while we're waiting for the reauthorization, we'll continue to accept EB-5 petitions. We'll hold them in abeyance. We'll put them in our drawer, but we'll give those applicants the benefit of the priority date it was filed if and when this reauthorization gets extended. So we have not heard that the USCIS is doing that as of this morning, but that is something that we'll have to wait and see. One thing about the EB-5 program is it's got bipartisan support. It clearly has helped infuse foreign direct investment into the economy and create jobs. And at a time where the economy is on its post-pandemic recovery, that is more important than ever. So we expect that to be happening. Why is that important? Well, what's wonderful about the EB-5 program is for India and China, it is current right now. That's a really critical aspect to look at, and it is expected to be current for some time in the foreseeable future. The processing time, however, is a little longer, although it may be shortened given the fact that there have been less applications within this year, but it is about 25 to 30 months. I'm seeing that the regional center applications filed on the same date as a direct investment usually process a little bit faster. And that's only because if the adjudicator knows what they're doing, they know that they have to give previous deference and they don't need to really look into the project aspect, but they just need to make sure that the foreign national has obtained, it has invested, that those funds are at risk and they are traceable to a legal means. So it's a great option if you have not started your perm process and you're an EB-5, because EB-5s are permitted to make passive investments. Now, that's another difference. If the center, the EB-5 center, whether you use a regional, EB-5 Regional Center or direct investment, they set it up as a partnership. There's certain rules that will allow that individual to kind of passively invest and still meet the regulation requirements. That's only in the Partnerships Act. Otherwise, you have to demonstrate that this person will have an active role in the business, either through their stock designation or through a specific role within the EB-5 center. So that's one thing to look at. Another thing is that EB-5 provides I told you the processing time is about 25 months to 31 months. Well, you get CSPA protection during that time. So if your child is under 21 and you're worried about their aging out, and I-140s are not going to take that long, this may be a way to preserve their date for a longer period of time. And remember, we have a video on how to calculate CSPA dates, so please check it out. Our folks will set up the link. Now, in terms of how to invest, whether it's the lower threshold or higher threshold, you can do that from multiple means. You can do that from a loan, a gift. You can borrow against your 401k, borrow against your house, your savings. You can get money from your brother, cousin, friend. You can get money from your home country or abroad. It can be from a variety of different mechanisms, with each mechanism very different in its application. And if you want, we've done EB-5 webinars. So I'm sure my folks will set up a link for our EB-5 webinar to give you more detailed information about the investment. Another mechanism that can be used, and a lot of EB-5 regional centers are allowing for that now, is if you don't have the entire investment, you can secure it through what's called a promissory note. Because indebtedness is allowed, and some regional centers will say, hey, make an investment of using the 500,000 analysis, make an investment of maybe 200,000, and then the 300,000 have it secured with a promissory note. There's a couple of things about securing it with a promissory note that's really critical to understand. There are actually three things. Number one, the promissory note has to be secured by the investor's asset. Asset can be a home, asset can be anything. With bank accounts, they're a little bit more weary. It also can be secured by assets overseas. The problem with securing it with assets overseas is one of the other prongs of how to make an effective promissory note is the asset has to be seizable. So you have to demonstrate that the individual can seize the property if it's an overseas property and can obtain a lien. So that is, so there, you can investigate now to see if you can find a EB-5 Regional Center that would allow for partial payment if and when the USCIS, they will state that they will accept regional center classifications. I mean, will accept EB-5 petitions again. The other thing to note is there's something called a diminutive value of promissory note. That means if you take that promissory note and put it in fair market value, sometimes the value of the asset gets diminished. So even if you are looking for securing a promissory note for 300,000, you might want to explore, depending on the type of asset that you are securing the promissory note with, to overfund it a little bit, so that even if it is diminished because of the fair market value, and for issues like currency conversion, and if you were to seize the asset, the cost of seizing the asset, they will look at all those things to determine the fair market value, that you will still be covered with the promissory note. So, we got to stay tuned to see what happens with these regional center, these EB-5 petitions. But clearly that's something that should be on everyone's radar. Like I've said, all paths lead to Rome. So in this 12-year wait, while Congress clearly can't seem to get anything done, if the USCIS does say that they'll start accepting, this really may be an option for you to look at, especially now given the lower threshold. We have to wait and see how DHS is going to contest this. Like I said, I don't believe that they will contest it through appeal. That's my personal opinion. But if they contest it through notice and comment, that will give us some time to actually, take advantage of this process. And as I've always said, we really like it if you share the love. Like us on Facebook. Where is this thing? Okay, let me close that and close that. Here we go. Like us on Facebook. Here's the Facebook link. If you've got your phone, all you have to do is put it up to the QR code and it'll take you to our site so you can like our Facebook. We also have a Telegram community. If you are not part of this community, it's an immigration community where we constantly try to provide updates, and we're talking to folks, answering questions, and you have other community members that are in the same situation that you're in. So if you have not joined our Telegram group, please do that. Again, put up your phone, take your camera out. If you once your camera is aimed at the QR code, it will take you right to our Telegram registration. And so share this with your friends, and please join us in the Telegram community. And last but not least, if you have not joined our weekly webinars, if you haven't registered for them on a weekly basis, or your friends have not, you can share the link here with your friends and have them join our community. And our YouTube, I'm sure my team will share the YouTube link. We have a lot of great information on YouTube. And if you subscribe, as and when we upload new information, you will be notified. So please subscribe to our YouTube channel, like it, give me your comments. We're always willing to, we always want to hear from you, and share it with your friends. That would mean a lot to me if you could do that. Any of these, any and all of these links. And so now it's time to get to what is the favorite part of most of you, what you've all been waiting for, which is our Q&A section. Like I said, please post your questions in the Q&A box and not in the chat box. That makes it easier for our moderator, Chandrasekhar Chawla, to review them and ask questions. So let's get started. Once Shekhar Chawla joins, then there he is.
Good afternoon, Lakshmi. Good afternoon, everybody. Nice to see you. And well, yes, it's Wednesday. Long weekend coming up. Hope everybody's got some plans. The only thing I will say is be safe and watch yourself. That's
Exactly.
all we can say there.
Yeah, enjoy July 4th.
Yeah. Okay, so let's see what's let's try to see if there's anything in the chat. There's no questions in the chat. So as we always say, put your questions in the Q&A and respond to any clarification in the chat. So let's go to the first question. Anonymous attendee. Hi, I am Shrikant. Sorry for deviating. If you have time, please answer. I have applied for I-485 EB-2. Priority date is January 2011. I've taken Canadian citizenship last week, wondering whether it would have any impact on my pending I-485.
I think if you're asking whether you're Canadian, the question is, the individual has a pending I-485 and they've obtained Canadian citizenship and wants to know if it'll impact the process. I'm going to assume that you're asking that question because you want to know if the Canadian citizenship is beneficial to your I-485. Well, in terms of determining visa backlogs and priority dates, they look to the country of birth, not to the country of citizenship. So even if you obtained another citizenship, unfortunately, it is dictated by where you were born. And if that wasn't your question, you were just seeing if it would negatively impact your I-485 process, no, it would not. One of the things you want to look for is if you're planning to really move to, I don't know what Canadian citizenship laws require in terms of moving to the country within a certain time frame, you want to keep things in mind, like making sure that you can demonstrate your intention to become a permanent resident if and when you get an interview. And secondly, that you travel to Canada with your advanced parole if you currently do not have an H-1B visa or a L-1 visa.
All right. The next question is another anonymous attendee. EB-3 priority date with May 15th, 2010. Based on current adjudication, when can we expect green card? In your firm, what is the current approval date pattern on EB-3?
So I had said last week, I think it is going to be, because initially first quarter, they were a little bit slower. The USCIS was a little slower in processing the AOS applications. They seem to have picked up in Q2. So I think by this summer we'll get because they're getting on the groove of kind of transitioning from the previous administration to this administration, transitioning from pre-COVID to post-COVID. So I think probably around July, August is when we can get a good sense of what the processing time is. And that's probably something that I will talk about in our next Wednesday webinar, trying to get some insights from my contacts who are there internally.
Okay, next question, another AA. Hello, Lakshmi ma'am. I filed my I-485 along with my spouse. At the same time, we also filed for extension of my H-1B and my spouse's H-4 and H-4 EAD. My H-1B is approved, but my wife's H-4 and EAD is not. At this point, her GC EAD is approved. If she uses her GC EAD, will her H-4 and H-4 EAD status abandon automatically?
No. You can be on H-4 status. The EAD is not connected to the status, only the H-4. And as long as it's pending, there is something called the 240-day rule. And maybe going over this rule next week will help. But as long as you file a timely extension, you're in valid status for 240 days. So you can, and there is something, I have talked on this in one of our webinars where I talked about unlawful presence versus status versus stay. So I think our folks know which webinar that is, but if not, email us and I'll show you. Otherwise, I'll post it up here. So there is a difference between the three. So she's in valid status. I mean, she's in a valid authorized stay, not in a valid status, an authorized stay. So she can use either, because of the H-1B having dual intent, she can use either the H-4 EAD or the AOS EAD, and that would not impact her because she's a derivative. So with the H-1, yes, you can use your AOS EAD, but remember, if you work for someone other than your H-1B employer, then you would have violated your H-1B status, and you would only be then on AOS, not on H-1B.
All right, next question, another AA. How long these 500K option will last for EB-5 in your opinion?
And this is just me, right? I think that I read the court case. There were a number of other cases unrelated to this where they said that the then acting Secretary of DHS did not have the authorization to act in that authoritative role. The federal government has a very clear way as to, how succession should be treated. And so the Federal Vacancy Reform Act actually outlines who, if there's a vacancy, who can take that vacancy, what authorization they can have. So I think DHS knows this. And so I think they know that they're not going to be successful on appeal. So I suspect that they are going to do notice and comment. Now, there is something that a mechanism that federal agencies can use, that is issuing a final rule that's effective immediately. They can only do that in very limited circumstances. You have to show that it is in the national interest to do that. There is a harm that you are trying to, an imminent harm that you are trying to correct. Like, for example, issuing a travel ban during a pandemic. You can do that through executive order or through expedited rule, because you can point to the fact that there is this health crisis, and it's due to that health crisis that the agency is acting in a certain way. Other than that, they can't. So I suspect that, they have to first issue the proposed regs. Then after issuing the proposed regs, it has to sit with, usually there's notice and comment, anywhere from 30 days to 60 days. That means they publish the regulations and say, hey, public community, if you've got any comments on these regulations, you can send those comments to us. They are supposed to then review the comments, make adjustments accordingly, and then issue final regulations. I have never seen that take place any earlier than I would say the average is 6 months, but 4 months would probably, even if they were acting very quickly, they would be able to, but it still has to go to the OMB. There's a lot of things involved. So I think we can see that this should be in place for at least 6 months.
Okay. Next one is from Sagar Kulkarni. Hello, Lakshmi ma'am. Nice to see you, and Shekhar sir. Thank you, Sagar. Joining your webinar after a long time. Your sessions are always so useful. Any timelines on the premium processing for H4 and H4 EAD? See, there is a final rule under the spring regulatory agenda. Again, thank you so much for all your service to the community. So he wants to know timelines on the premium processing for H4 and H4 EAD.
Yeah, I think around November of last year, there were many other categories that they wanted to include with premium processing. And I think that's probably what you're seeing in the spring update. The only thing is and you think that with premium processing, with the fees being so high, that they could hire additional people. So I think it's trying to work out the logistics of onboarding new resources to address what would be a tremendous influx of premium applications and managing that. So, we're definitely keeping our eye on it, and we'll let you know. Hopefully, if you've joined our Telegram group, our folks put up the links in the chat, and you've connected with us. You'd be able to see it that way. I want to thank you for joining our webinar, and I appreciate your positive feedback. That is our purpose. I wanted to ask the attendees who are here today, how many of you are joining us for the very first time? Can you raise your hand? Wow, we've got, I think, 5 new people. So I want to welcome the attendees that are attending for the first time. Thank you for joining. There's 6. And for all of you who've been joining us every week, I appreciate the fact that you've been joining us each week. So thank you to all of you as well. And for those attending new, if you haven't subscribed to our YouTube channel, there's a lot of information. We've been doing this since last March, and it's chock full of information that can help you on all different aspects of your immigration journey. So please check out our YouTube channel and subscribe so you can get updates on the latest information.
Okay. Next one is on EB-5. Based on your experience with past applications, how long will it take to receive a green card if we start a EB-5 visa today? How many stages, timelines, born in India and source of funds clean and every penny in USA?
Oh, fantastic. That's really good. So what you do is you have to identify whether you're going to do a direct investment or an EB-5 regional center. And in regional centers, if you're going to do that, please do some due diligence on looking at the regional center. You want to look at how many projects this regional center has done. You also want to look and make sure it's not an incredibly large endeavor. I've seen some regional centers, their overall project is within the 100 million, and with something of such a high threshold investment, so many things could go wrong. So I would look for a smaller project. I would look to see if the regional center has had projects that they've worked with before. I won't work with every regional center because there's a lot of them that once I've reviewed the documents, I found it to be very questionable. Have somebody who is good with numbers and finances, kind of take a look at all the financial information they should be providing, and make sure that the EB-5 Regional Center has skin in the game. If they haven't invested in their project and they're using all EB-5 money, I'd be really skeptical of that because they have nothing to lose. It's your money they're playing with. But if they have invested a lot of money into that regional center, then that, would mean that they have a invested interest in making sure that that project is successful. Time frame is anywhere from 25 to 30 months. And India is current and probably will be current in the foreseeable future. We haven't been seeing, especially during the pandemic, a lot of EB-5 applications. So I think that 25 to 30 months, maybe even shorter, which is a good thing. And, if and when if you want to email us, we'll keep you posted and let you know at info@chalalaw.com when the USCIS, says, hey, while Congress is trying to work this through, we'll go ahead and accept applications. But that is, if it's all the money is in the US, if it's clean, this is really a good mechanism to use to get your permanent residence in the United States. So initially you file an I-526, like I said, time frame. And then once the I-526 is approved, you get a conditional permanent resident card. It is no different than the actual permanent resident card. And then 2 years after the approval of that, you have to file to remove the conditions. And what is the issue when you file to remove the conditions on your conditional permanent residence? Have the 10 jobs been created? So you're looking at 24 months, then another 2 years. That's 4 years. That's why I'm very weary of direct investments in small projects. We do them all the time, but if it's a smaller enterprise, if they're not using indirect jobs, if something should happen, whether it's to that industry, new regulations, new or some other catastrophe comes into play, then that could impact that particular direct investment ability to create those 10 jobs. So with an EB-5 Regional Center, they use indirect jobs. So a lot of those jobs are already created and accounted for. So as long as you can determine, look at what the economic analysis is about the job investor ratio and have proof that they are under construction and they are actively trying to do whatever it is the project that they're doing, then I think that that's a safe way to secure your permanent residence.
Yeah, well, this message is from an anonymous attendee. So, but I just wanted to add that if you're interested, I can talk to you about some regional center projects that I know of. So just send an email to info@chalalaw and I will respond to you directly.
Or why don't you put the Lexpert link email?
Yeah, let me just put it there.
And so, and like I said, remember that it preserves CSPA date. We had an EB-5 petition that initially he was debating on whether to file with some cousin's friend who was a doctor in Florida, and he was starting an EB-5 project. He says, it's a well-known person to us. He's like a family friend. And I said, how many projects has this doctor done? He goes, none. And I said, well, look, tell your CPA to look at the financials. It doesn't matter to me. I get paid either way, but I like to see my clients become successful with their EB-5 applications. And the CPA was just very weary. Later, that project was shut down. So, and a lot of people were out of money as a result. And for this investor, he finally decided to go with a known EB-5 Regional Center. We filed his I-526 a day before his son turned 21. And his son was in the US on an F1. The father was a primary investor, but he had to make sure his son was under 21 to leverage it. It was pending for 24 months. And so 24 months was added on to the date of the child. And so once it became current, you have to file within that 1 year. And we were able to do that. And they not only have got their conditional, but they're now they've already filed for removal of the conditions on the green card.
Well, next one is another AA. Any idea when 2017 will become current for filing date India, EB2 or EB3?
Right. I am going to try to do some of that analysis if I can get the data that I've been looking for in terms of what has been processing per month. And we'll try to give you some of those stats next week. And then we can kind of, based on, if you look, we had a webinar that talked about how DOS comes up with the visa bulletin dates and how it interrelates to the USCIS processing. So they are interrelated. And my team will put up that video, a link to our YouTube video that talks about that. So you can understand that it's not in a vacuum, that they kind of all intercorrelate together. So I'll try to have some of those stats for you next week.
Next question is from Shilpa Nistani. Hello, I had biometric appointment today morning. The appointment letter stated I-485 receipt number, but the status was updated for my I-765 number. Is this normal? I think something is missing, maybe not updated. The appointment letter stated I-485 receipt number, but the status was updated for my I-765 number. Or maybe, is this normal? If not, what can be a way to handle the situation? Call USCIS, any pointers appreciated.
Yes, you should, it's probably just a simple mistake, but it's nevertheless a good idea to get that corrected. And we had a session that talked about in detail about how to contact USCIS. It's not just one way. It's not just Emma. It's not just, the 1-800. There are a number of ways. And so look at this YouTube video, and it tells you all the information about who to contact. And Kara, do we have, are we going to try to launch our poll again this week to see how folks have heard about us? I think we've had, okay, here we go. There we go. I'm launching the poll now. It would be really nice if you all could respond to the poll that I have launched, and would love to hear back from you. This just makes our programming better and clearer. So Shaker, he may have an emergency phone call. So while he is answering the phone call, so there are many ways you can contact them. So I would contact them and make sure that, you get that rectified. So take a look at that video. It gives you phone numbers, email addresses, what information you have, what you should provide to contact the USCIS.
All right, next question is, what is your thoughts on Charlie update? Will USCIS use all spillover?
Yeah, he seems to be very, very, he's projected a very positive outlook for that. We'll have to see. I think by end of July, we'll have a good sense of what's outstanding and what's been adjudicated to find out whether they'll be able to make it to, the spillover numbers by October this year. Remember, a USCIS operates on an October to October fiscal year. So the new numbers come out October 1st of this year. And he also stated, if you joined us last week, I had outlined this, that the numbers would be aggressively moving forward up till mid-2022. So that's good news all the way around.
Okay. Next one is from another AA. Hi, my EB2 PD is October 2009. Filed my I-485 OAOS in July 2012 and received my EAD. Recently received I-485 RFE and submitted the reply for the same on June 11th. Also, soon after that, received a letter from USCIS where they have applied my fingerprints on record to the file. In how much time should I expect the decision? My current EAD expires November 2021. Should I also apply for EAD renewal? If so, what is the right time?
You can file for the EAD renewal, and I think you can file within, I thought it was within 90 days of the expiration, so probably very shortly would be a good time. And I would go ahead and file the EAD renewal just in case. The other thing is to note, once you do get an adjustment EAD, remember they're going to be increasing EAD approval notices for a longer period of time. And adjustment EADs, the mere filing of it gives you that 180-day protection, just like you have when you file an extension for an H-1B, the 240 days. For an EAD, it is 180 days, but only applies to certain EADs. So AOS EADs are one of them.
All right. Another question from an AA, is EAD and AP renewal application should be sent 6 months before expiry or 120 days before expiry?
I believe it is because it used to be that they were required to adjudicate the EAD within 60 days, believe it or not. And so I remember that if we had EADs that weren't adjudicated within 60 days, we were able to send them to a USCIS field office where they could get a temporary EAD extension. They're no longer doing that ever since they added the 180-day rule. So I believe it is 120 days, but Kara will, there she goes, 180 days. Kara responded. You can file your EAD up to 180 days early. So that's what I would do for your EADs. File it as soon as you can because of the processing delays.
All right. Next one is from Sanjay Pathak. Is there any update from government on children who are aged out and not eligible for 485 with family? Can I file a 485 after getting my GC?
Well, you could file an I-130 petition, assuming that your child is unmarried, for an unmarried son or daughter of a green card holder, but over 21. But Congress hasn't acted yet, so there's nothing right now that is a ready remedy available. And that's why I tell people, look at the CSPA issues before your child turns 21. There are things you can do. You can file other petitions. You know, as I told you earlier in the illustration for the individual that filed the I-526 for an EB-5 application, it was filed a day before his son turned 21. And so he was able to be protected under that. So once that happens, though, once they turn 21, the remedies available are very limited, literally none, except for either having the child have their own process or having the child be sponsored by the parents. And that is a pretty long time frame. The other thing I would think of, if you can, think about filing an EB-5 for your son, especially if your son or daughter, they're already in the United States, maybe on an F1 because they're over 21. They're, this is one way in which they could probably get their green card a lot faster.
All right, next one is from JG. I am EB3 PD, 2014 September. Let's assume FD reaches EB3 by 2014 December for EB3 by next 2 months. When the visa number will be allocated so that visa numbers are not getting wasted. Just want to understand the process. Thank you in advance.
Right. It's kind of complicated. I did talk about it in a YouTube video previously, but like I said, I think next week I'll try to go through the math with you. I'm gonna have to take Shaker's help. Not very good at math. If I was good at math, like every other, most Indians, I would have been an engineer or a physician. So because my math skills were not that great, I went into law. But that's good for you because I'm very good at least analyzing the law. So I'll have those numbers for you and kind of show you how that plays out next week. So please join us then. And, you know, like I said, next week is going to be, because we're going to try to talk about, you know, issues relating to expiration of status on H's, what's the 240-day rule, things relating to how the USCIS processing time affects the DOS numbers, and what are we looking at? And I'll probably have a PowerPoint just so I can show the numbers live when we start next week.
Yeah, how much time do you have?
I have till 1.
Okay. So we have another 11 questions. So
yeah, and if you haven't gotten your question answered, I'm going to be talking to my Telegram group today. I've asked them if they wanted me to do, you can do a Telegram group live where you can talk to the people within that community. So I'm going to try to do that this week. And so if you haven't gotten your questions answered, if Kara can put up the Telegram group link again, join that, and we'll have a one-on-one conversation. We'll have some chai, we'll talk, I'll answer your questions.
okay. So on that note, please, you know, send your email to info@shalalaw, so we may not be able to answer any other questions that will be, you know, after the one that is here. The last question is that it's an anonymous attendee, so I can't even know who the person is. Anyway, next question is from an anonymous attendee. Any thoughts if you think the priority date of August 2014 has a chance to get current in fiscal year 2022 in EB2 or EB3 India?
Yeah, I mean, and what was the month?
August
August.
2014.
Yeah, 2014. You would have to move by a year. We have been seeing how EB3 has been moving pretty aggressively. So we just have to see how many USCIS petitions were adjudicated and for which category. And then we can have a better understanding of how that would affect the DOS movement. I would say that there is a good chance, and I'm saying this without looking at the numbers, just kind of guesstimating. But next week, I should have a better sense of giving you an answer on what the projection should be.
Okay, next question is from Michael Tellis. Apologies if this has been addressed already. I'm getting confused as to how Charlie from DOS says there will be no retrogression for EB3 India when such low amount of EB processing was done for the first half of 2021, and he has not accounted for EB2 to EB3 downgrades. Could you shed some light?
Yes, and it's because he said that, I mean, he actually said, not only did he say there won't be a retrogression, he said that there would be advanced, the numbers would still be, there'd be advanced movement until mid next year. Remember, family-based, there's still a travel ban. And so because there's still a travel ban, a lot of the family-based petitions are not being still processed, even though they should be given priority. You have to meet certain requirements, but it's because people are not because of an immigration ban, but because of the pandemic. So that's really impacted the numbers most of 2021 as well. So he had outlined how I know that there's a lot of Ravikant Nisteni seems to be given his, would you like to take over the webinar, Ravikant? His insights to this. But what Charlie said was it would be rapid movement until mid-2022. Will there be a retrogression after that? Most likely, if Congress doesn't act. And we suspect that, but it's not going to be one that's going to happen prior to that because of all these other factors that have to be looked into.
Okay. Next question, another AA. Hello, Lakshmi ma'am. Thanks for your time and giving us valuable information to us. I have a question on my status and how would it impact my adjudication. My H-1B extension got denied a few months ago. Employer filed a new H-1B and got approved recently. Unfortunately, there was a gap between old I-94 and new I-94 dates, exactly 1 month. Is this considered out of status? My PD dates will be current next month in EB-3. If I file 485 next month, will there be an issue for 485 adjudication?
So did she say she had a denial because it was a change in employer, or was it an extension?
There's nothing mentioned, and whoever this person is, I don't know the name, you can respond in the chat.
Well, here's the thing. What your attorney should have done is ask for a nunc-pro-tunc when they refiled. Nunc-pro-tunc means go back to the original, means go back to the original date of filing the previous H-1B. And we've had that where there has been, we had one issue where an employer unknowingly merged two of his bank accounts. They were working with another law firm, and what happened was the USCIS accepted and approved the extension. And then when the checks wouldn't clear, they denied it. It usually doesn't happen that way. But their attorney at that time said, there's nothing that can be done. And I said, I think there's something that can be done. There is a deference provision within the statute, and you can ask for nunc-pro-tunc. So we did that, and we cited that they didn't follow policy. We cited, I found a regulation that talked about how federal agencies are supposed to cash checks within a certain time frame. After reading a 30-page federal court decision, I found a footnote somewhere, and I was able to use that. And we did get it approved with a nunc-pro-tunc, where the approval notice we asked for was from the previous. Now, you can have a lapse of status as long as you weren't working without authorization for 1 month. So I don't think it should truly impact your ability if you got another approval notice with an I-94 card attached to it. Without knowing why your previous one was denied and not knowing a lot of the other details, I wouldn't really be able to give you any clear advice. Remember, everything that I discuss on this webinar is just general information. It is not deemed any legal advice. We do not have an attorney-client relationship if you are not currently my client, and you should always seek, the assistance and review of whoever your attorney is. I'm just giving you information as talking points to talk to them about. So without seeing your documents, I can't say it. But for the most part, that 1 month in lapse of your I-94 card, because you filed prior to the expiration, should not be a problem. But like I said, that's without seeing all your documentation.
Next question, other AA. Any thoughts on the latest chats with Charlie episode? especially the potential EB green card wastage. Who's this Charlie?
It's Charlie
He-
Oppenheim,
So
who
popular.
has these talks once a month. He didn't have it last month. He's the one that he heads up Department of State's visa bulletin issues.
Somebody should start a counter talk of Charlie's.
What would a counter talk be?
Just whatever he says, try to respond to or give a spin to what his opinion is.
Maybe we can start a
Sometimes his
Charlie.
opinion, sometimes most of these people, they don't seem to be liking his opinion.
No, but his opinion counts because he's the one that's in office. And he says, I think people take sound bites out of text. You take one thing, or somebody tweeted one thing, or somebody, you have to listen to his presentation in its entirety and understand how the processes relate to one another. So, like I said, stay tuned next week, and we can talk about Chuck next week and what his predictions are, and address some of the confusion that I think a lot of people are having on the interoperability of the USCIS and the DOS.
All right, next one is another AA. Australian citizen, can I apply for franchise like Wendy's, etc. on E2 visa?
Yes, you can. And in fact, we had a session, Shakers with Transworld Businesses, one of the largest franchise, one of the largest business brokers that has franchises. And we did a session on owning a franchise and how that can help you as you're going through this process. So yes, that is very much an option. If you want, email us at info@cellolaw.com, or Shaker, you can put up your.
I already put, I can put that one.
Transworld email and look at the franchise, because we go through and we look at different franchises. There's really a litany list. I've really enjoyed searching the franchises to see what's out there. And because the E2, you can change your status in the US. You can actually structure it in such a way that all the functions are, all the money and everything else is conditioned on the approval of the E2. So take a look at our webinar on franchises and immigration. And that's one of the reasons why, Shaker started doing this, is because whether it's E2s, because it's not just franchises Transworld has, it has businesses, whether it's L's. I tried to work with different brokers, but they didn't understand the immigration requirements that these visa classifications had. And so with Shaker, it was good because he understood and so we could match people up with the best opportunity.
Yeah, please send an email to cchannel@tworld.com. I'll be glad to send some information. I can also add you to the mailing list with your consent. So you'll get weekly, once a week. Every Thursday, you'll know what businesses are available, are hot. So, that's something that can help you. Thank you. Another one, next one, another AA. One follow-up question on my Canadian citizenship and pending I-485. Do I need to file any form updating my citizenship for USCIS records?
Not really, because you acquired it afterwards. Most people are getting waived for the interview. So if you get waived for the interview, it's not really something that's germane to this process. So no.
All right, so we said we will not take any more questions. I got a name now. Michael Tellis will be the last person at 12:53. After that, no more questions, please. Next one is on AA. Hi, Lakshmi and Shekhar Garu. Thank you for your service to the immigration community. I need your suggestions. Appreciate whoever this person is. I have received my GC yesterday, filed at AOS in October 2020. All right, congratulations, with all the documents, including medicals. What are my next steps after receiving my GC? I think the same person. Should I continue my current employment, or how long work with it was? I think maybe a different one. Okay.
Yeah, so next steps would be, from an immigration perspective, it is citizenship. You want to make sure, if your path is citizenship, there are two things about permanent residence. One is making sure that your travel outside the United States doesn't impact your ability to become a citizen. And so you can't stay outside the United States for more than 6 months. And it's not that your green card will be nullified if you stay for more than 6 months. It would impact your citizenship because remember, you have to be a permanent resident for 5 years, and 50% of that time you have to reside in the United States. So if you are outside the United States for more than 6 months, that 5-year clock starts once again. So it impacts you from a citizenship perspective, doesn't impact you from a green card perspective. From a green card perspective, you can't stay out of the United States for over a year. Otherwise, you would have deemed to have abandoned your permanent resident process. That's what happened to me in 1982. So, and my father didn't know that by taking me back to India in 1982, that would be a problem. I had arrived here in the early 60s with my mother, but I was born in India. I was the only one of my siblings that had that problem. And for whatever reason, my dad didn't want me to become a US citizen. He didn't want to become a US citizen up till much later. So I came to the United States because of Mr. Chawla. He came on an F1 and I came on an F2, and then we embarked on this process all over again. So that's something that I tell all my clients, and I tell them to take it very seriously. The exception to that is a reentry permit. You can get a reentry permit so you can stay outside the United States for up to 2 years, but that doesn't protect you from the citizenship side. So you still it would still impact your ability to become a citizen within 5 years, but it's not, if you get the reentry permit, it's not going to impact your green card. I hope that answers your question.
You know, you should have met me, or we should have met a little earlier, because when I met you in 1984, by the time, and I asked you, right, about your green card, by the time it was already 6 months old, you know. So if we had met before, and even if your dad was not convinced, I would have.
Yeah. Well, you shouldn't have taken so long to meet me.
I've tried. Yeah. It's my uncle who was acting on my parents' behalf, but I don't want to.
He was a little slow.
No more, yeah. So I can't. But anyway, so yeah, you got to act fast, you know.
Well, you know, and
because in life, act fast. Don't procrastinate. That's all.
Right, because we went through that. You know, we take this very seriously. My team takes it very seriously. They work really hard to put this piece together. Shout out to Kara and everybody else at Chella Law for putting these weekly webinars together. And I want to thank Shaker for for moderating, all of you for all your support and kind words that you've shown us. One of the biggest favors you can do for all of us that work really hard, Kara would love this, especially. So I think we dedicate this gesture to Kara for all the work that she does, is make sure you share this information with your friends so we can build up our immigration community and get this word out and help folks. It surprises me how many people are not aware of all the things that we talk about every week. So please share it with your community. Join us next week. We'll do some numbers and talk about the visa bulletin and things like that. And have a safe July 4th. I think Shaker wants to say something.
I got 2 more questions, actually. We didn't take 2 questions. So do you have time, or should I ask them to?
We were supposed to quit by 1, but if you're it's Independence Day this weekend, which, by the way, was a celebration of the United States becoming independent from British rule. So it was a celebration for some of the first immigrants that came here to the US. So it is. Right. Go ahead.
I'm sorry, but you know, if you couldn't answer your question, please send an email and we'll be glad to do that. I think your attorney has another appointment and she didn't want to be late for that. So I apologize. Do a better job of moderating from next time.
So if you haven't gotten your questions answered, we always want to help you. Join the Telegram group. I'm going to be on there later this afternoon to try to answer some questions that are on there. I'm probably going to try to organize a Telegram group live where I'm talking to everybody within the Telegram group and answering questions live, either tomorrow or probably either tomorrow, because we have another, I'm talking to the NC Delegate Association group on Sunday, so I won't be able to do it Sunday. So please do that. And we did a Facebook Live last week. It was my fault. I'm not very technologically savvy and I couldn't figure it out. And it just kept kicking me out. But I'm going to try to do, a trial run of that again. And we'll test that out to see how that works. But thank you all. Have a safe and happy and fun July 4th weekend. I look forward to seeing you again next week with the latest immigration updates. Thank you, Shaker. Thank you all. Have a good week.
Thank you all. Take care.